Recognizing the member for West Kelowna Peachland.
Thank you, Madam Speaker. I'm going to keep this pretty straightforward. People should be able to go to their place of worship and not have to think twice about their safety. That's it. That's the baseline. But that's not where we are right now. There are people in this province, families, who are making decisions about whether it's safe to attend a service. They're thinking about what might be happening outside before they even get there. That's not normal, and we shouldn't accept that as normal. We've all seen what's been happening. There's been an increase in targeting of religious communities, and in particular, a real rise in anti-Semitism. That's not something distant. That's happening here in British Columbia. And when that's happening, people expect more than statements. They expect action that actually changes the situation. So I don't think there's any disagreement in here about the goal. People should be able to attend worship safely. They should not be intimidated, and they should not be blocked from getting in. That's not a controversial position. Where this starts to matter is how we get there. Because if we're going to bring in legislation like this, then we need to be clear about what it's actually doing. And whether it's dealing with the real issue or just reacting to what we're seeing on the surface. And that's what I want to walk through. And this is where I think we need to take a step back for a second. Because this bill didn't come out of nowhere. Government is responding to something real. There have been incidents, there have been pressure to act, and communities are saying they don't feel safe. That part is clear. But the question I keep coming back to is this: how did we get here? Because when people are having to worry about their safety just to attend worship, that's not just a one-off issue. That points to something bigger. It tells you that somewhere along the way, the system that's supposed to prevent that from happening isn't doing what it's supposed to do. And now we're here bringing in legislation to deal with it. And again, I'm not saying don't act, of course act. But we should also be honest about what this represents. This is government stepping in after the fact, trying to manage a situation that has already escalated to the point where people don't feel safe. And I think that matters. Because if we don't look at how we got here, then we're just going to keep responding the same way every time something like this happens. There are communities right now that are spending significant money, their own money, just to make sure people can attend services safely. That shouldn't be the expectation. Public safety is not something communities should have to fund on their own. So yes, government is acting here. But at the same time, I think it's fair to say this didn't need to get to this point in the first place. And that's why, as we go through this, I think it's important we don't just look at what this bill is trying to do. We also look at whether it's actually getting at the root of the problem. Now, I want to be clear about something before I go any further. We support this bill. People should be able to go to their place of worship without being intimidated, without being blocked, and without having to worry about what's happening outside. That's not something anyone should have to argue for. So the idea behind this, creating a way to protect access, to deal with disruption, that part makes sense. But supporting this bill doesn't mean we stop asking questions, because this can't be the only answer. And it can't be treated like it solves the problem on its own. This is one piece, and if we're being honest, it's a piece that comes in after things have already gotten to a point where people don't feel safe. What concerns me is when legislation starts to become the go-to response, instead of looking at whether the system we already have is being used the way it should be. Because we already have laws, we already have enforcement tools, we already have the ability to deal with behavior that crosses the line. So while I support what this bill is trying to do, protecting people, protecting access, I think it's important that we don't treat this as the solution. It's not. If anything, this should be a signal that something else isn't working the way it should. And if we don't address that, then we're just going to keep coming back here, adding more legislation, trying to deal with the same issue from a different angle. And that's why I think we need to look a little deeper at what's actually happening and how we're choosing to respond to it. And that is where I think we need to bring this back to something pretty basic, because this is being talked about as a public safety issue, and I agree with that. If people are being intimidated, if access is being blocked, if there's a disruption outside a place of worship, that is a public safety issue. There's no question about that. But if that's the case, then we also need to be honest about something else. We already have the laws to deal with that kind of behavior. They already exist. Police already have the authority to step in when things cross the line. That authority comes from the Criminal Code of Canada, and it covers the exact types of behavior we're talking about here. Intimidation, harassment, causing a disturbance, obstruction, mischief, causing fear. These are not new concepts. These are established offenses that have been around for a long time. And they're not just written down somewhere. They've been used. They've been applied in real situations. They've been tested in court, and they've been shaped over time to make sure they align with the Charter. So when I hear that we need to bring in new legislation to deal with this type of behavior, the question I have is why? Because from a policing perspective, there isn't a gap here. If someone is crossing the line into intimidation, there are already consequences for that. If someone is blocking access, there are already ways to deal with that. If someone is creating a disturbance that affects public safety, that can be already addressed. That's the system that's in place, and it's a system that's designed to balance enforcement with rights. So this isn't about whether we have the tools. We do, and we've had them for a long time. The issue isn't the existence of those tools. The issue is how they're being used and whether they're being used effectively. Because when behavior like this is happening and communities are still feeling unsafe, that tells you something. It tells you that either those laws aren't being applied the way they should be, or there aren't enough resources to apply them consistently. And that's a very different problem than a gap in legislation. So when I look at this bill, I don't see something filling a hole in law. I see something stepping in where existing law should already be doing the job. And that's why I think it's important that we don't just assume more legislation equals better outcomes. Because if the underlying issue is enforcement or capacity, then adding another layer doesn't fix that. It just changes how we approach it. And before we move further down that path, I think it's worth taking a closer look at what that actually means in practice. And this is where I think it's important to understand what this actually looks like from a policing perspective, because there's a real difference between enforcing a criminal offense and enforcing a provincial act. Those are not interchangeable. No matter what authority a province gives police, whether it is the ability to arrest or issue a ticket, it does not carry the same weight as a criminal offense. It just doesn't. A criminal offense operates at a higher standard. It has to be proven beyond a reasonable doubt. An officer needs reasonable and probable grounds to believe that an offense has been committed before taking action. There's a process that follows that is structured, well understood, and consistent across the country. And more importantly, it's been tested over decades in courts, under scrutiny, with challenges that have shaped how those laws are applied. So when a criminal charge is laid, everyone understands what that means. The public understands it. The courts understand it. Police understand it. There is weight behind it. There are real consequences attached to it. And there are tools that come with it that allow that situation to be managed properly beyond just the moment. Provincial ticket is different. It operates at a lower threshold. It's designed to address behavior quickly and efficiently, usually for regulatory or lower level offenses. And again, there is a place for that. We use those tools every day. The Motor Vehicle Act is a good example. The Liquor Control Act is another. Immediate roadside prohibitions. Those are all examples of where a provincial framework makes sense. Those are situations where the goal is compliance, not escalation. They are not designed to replace criminal law. They are designed to sit alongside it for specific types of behavior. But what we're talking about here is different. This is not about convenience or efficiency. This is about conduct that, in many cases, already meets the threshold of criminal behavior. someone is intimidating individuals trying to access a place of worship, if someone is blocking entry, if someone is creating a situation where people fear for their safety, those are not minor regulatory issues. Those are serious. And if they meet that threshold, they should be treated as such. Because once you move away from that, once you start addressing that kind of conduct through a provincial framework, you are lowering the standard of response. And that has real consequences. With a criminal charge, an officer has additional tools. They can release a person on conditions. They can impose restrictions not to return to that location, not to have contact with certain individuals, not to engage in certain behavior. That creates ongoing protection. It doesn't just deal with the moment, it manages what happens after. This legislation doesn't provide that same level of protection. It allows for an arrest, it allows for a ticket, but it doesn't carry the same follow-through. And that matters, because public safety is not just about what happens in the moment. It's about preventing it from happening again. There's another point here that I think is important. In British Columbia, it is not common for provincial legislation to grant police the authority to arrest in this way. Typically, those powers come from the Criminal Code of Canada, which is a much stronger and more established legal framework. And there's a reason for that. Because an arrest is one of the most serious actions the state can take. It is the state limiting someone's liberty. It directly engages their right to life, liberty, and security of the person. That's not something that is taken lightly. And in our system, that kind of intrusion is justified when someone commits a criminal offense within a framework that has been tested, challenged, and upheld over time. This bill doesn't come with that same history. It hasn't been tested in the same way. And yet, it is extending that level of authority into a different context. And from a practical standpoint, I'll say this. If an officer is on scene and the behavior meets the threshold of a criminal offense, they are going to use the criminal charge every time because it gives them stronger authority, it gives them clearer direction, and it gives them better tools to actually protect the people involved. So when I look at this, I don't see something that strengthens policing. I don't see something that simplifies decision-making. If anything, it creates a parallel option that doesn't carry the same clarity or consequences as what already exists. And that doesn't make the job easier. At the end of the day, if someone commits a criminal act, they should be dealt with through criminal law. That's what the system is there for. The response should match the seriousness of the behavior because the punishment should fit the conduct. Now, I want to talk about something that I think sits at the center of this, because this bill doesn't exist in a vacuum. It exists because communities don't feel safe. And when you get to a point where people are relying on legislation like this just to be able to access a place of worship, you have to ask why. Right now, there are communities in this province, particularly Jewish communities, that are spending significant money on private security. Not occasionally, every month. We're talking about over $100,000 a month being spent just to make sure people can attend services safely. Now think about that for a second. Families going to worship and security has to be part of the plan. That shouldn't be the expectation in British Columbia. And what makes it worse is this. They're not just paying for that security, they're being taxed on it. 7% on PST, something they are being forced to put in place because they don't feel protected otherwise. That's not right. Public safety is not something that should be downloaded onto communities. It's not something people should have to fund themselves just to feel safe doing something as basic as attending worship. That's the responsibility of the government. So yes, this bill is a step. It acknowledges that there's a problem, but it doesn't address why communities are in the position to begin with. Because if people still feel the need to hire private security after this passes, then what has really changed? That's the question. You cannot solve a public safety issue by shifting the burden onto the people who are being affected by it. And you cannot treat legislation like this as the solution when the underlying issue hasn't been addressed. Because at the end of the day, people don't want access zones, they don't want security barriers, they don't want to think about any of this. They just want to be able to go to their place of worship and feel safe. And right now, too many people don't. And I think we also need to talk about what's happening underneath all of this. Because situations like this don't just show up on their own. When communities start to feel less safe, when people start changing their behavior, thinking twice about where they go or what they do, there's usually a reason behind it. Right now, the provincial RCMP contingent sits at 2,602 officers. That number hasn't changed since 2012. Over a decade, not one additional officer has been added to the provincial contingent. Now, think about everything that has changed over that same time period. Population has grown, communities have expanded, the demands on policing have increased, the complexity of the work has increased, but the number of provincially funded officers has stayed exactly the same. So I think it's more than fair to ask, has that had an impact? Has that contributed to what we're seeing now? Because policing isn't static. You don't just hold the line at the same level and expect the outcome to stay the same when everything around it is changing. When capacity doesn't keep up with demand, pressure builds, and eventually that pressure shows up somewhere. It shows up in response times. It shows up in how quickly police can get to a situation when something is happening. It shows up in visibility, whether there are officers present in communities in a way that people can actually see and feel. And that visibility matters because policing isn't just reactive. Presence alone changes behavior. It deters, it reassures. It creates a sense that someone is there and that something will happen if the line is crossed. When that presence starts to thin out, people notice. They may not always be able to explain it in technical terms, but they feel it. And when people feel that absence, they adjust. They start looking for ways to fill the gap themselves, which is exactly what we're seeing here. Places of worship bringing in private security, communities organizing their own security measures, spending significant amounts of money just to create a level of security that should already be there. This is not how this is supposed to work. Public safety is a core responsibility of government. It is not something that should be downloaded onto communities, especially communities that are already dealing with being targeted. And if there had been a sustained effort over the years to increase that provincial complement, even gradually, more officers, more presence, more capacity, that would have had an impact. More officers on the ground mean more visibility. More visibility means stronger deterrence. And stronger deterrence means fewer situations escalating to the point where people feel unsafe. That's the connection. And I believe it would go a long way toward what we're talking about here. People being able to attend their place of worship without hesitation. People feeling secure in their communities without needing to think about additional measures. Because at the end of the day, public safety isn't built through legislation alone. It's built through presence. It's built through capacity. It's built through making sure that when something happens, there are people there to deal with it. And if we don't address that piece, then there's always going to be reacting after the fact instead of preventing it in the first place. So when I look at this bill, I see something that is necessary. But I also see something that shouldn't have been necessary. People should not be in a position where they need added protections just to attend worship. It should already be a given. And the fact that we're here tells us something. It tells us that something in the system isn't working the way it should. People need to be protected. Access needs to be protected. And when there are real concerns about safety, government has to step in. But we shouldn't pretend that this is the solution, because it's not. Because if the underlying issues aren't addressed, if enforcement isn't consistent, if resources aren't there, if communities are still left to protect themselves, then nothing really changes. And that's what I keep coming back to. People in this province should not have to think about security when they go to worship. They shouldn't have to wonder what's happening outside. They shouldn't have to rely on private measures just to feel safe. That's the standard. And right now, we're not there. So yes, this bill is a step, but it's not the answer. The answer is making sure that the systems we already have are working the way they're supposed to, that the laws that already exist are being enforced, and that the resources are there to support that. Because at the end of the day, this comes down to something simple. People want to feel safe where they live. They want to feel safe practicing their faith. and they want to know that the system is there to support that. That's the expectation, and that's what we should be delivering. Thank you.